Hello, good afternoon. I see people are starting to join us. Welcome and thank you for signing up for today's MCLE class. With me is Nick Cohenmeyer. I'm going to do a little bit of housekeeping before we get started and give everybody a chance to log on. My name is Nicole Gelati and I'm from the San Diego Law Library. I just wanted to tell you a little bit about the presentation today. If you have any questions during the presentation, please use the Q&A feature and I will feed questions to our speaker. And if we have time at the end of the class, we can try and go over them. This is a CLE presentation today, and we'll be emailing out certificates and the handout to everyone who is verified in the Zoom to have attended today. So be on the lookout for that email later this afternoon. And lastly, you'll see a survey link at the end of today's program. We'd be very appreciative of anyone who took time to take our quick survey and give us some feedback on our program. So thank you in advance for that. With that, I'm going to turn things over to Nick.
All right, I'm going to go full screen and please let me know that you see the full screen right now. Can somebody confirm?
Nick.
Okay, it says security deposits in California, right? Okay, so I'm not hearing anything, so hopefully that was a yes.
Yeah.
Great. Okay, cool. So today we are talking about security deposits in California. Now, this is going to be a presentation, obviously, that is more advanced than the one we previously gave for the community. If you are interested in a slower pace with less technical jargon, fewer citations to the civil code, get with the San Diego Law Library for the recording of that presentation. I will also make it available on my YouTube channel. Today, we're going to be discussing how you can advise your tenants or your clients for proper compliance with security deposits. If you are a landlord yourself, these are important things to know. And as I like to say, don't learn the law as a defendant. So all of you are probably attorneys here or just really passionate individuals about security deposits. And you all know that ignorance of the law is not a defense. So you should know, and you're expected to know these regulations when you are advising your clients for security deposits in California. So obviously, I'm a lawyer, have to make a disclaimer, can't not make a disclaimer. So general legal advice, this is not going to be specific to any one person's situation. If you need an advice, well, normally I would say if you need advice, talk to an attorney. So maybe talk to one of your colleagues. So this is going to be a high level overview with many specific matters, but obviously every situation is different. And just because the law seems relatively clear, it still comes down to how a judge would interpret the facts to the law, obviously. The primary source for today's presentation will be California Civil Code 1950.5, which will be entitled Security for Rental Agreement for Residential Property Uses Dwelling of Tenant Amount and Disposition Damages. I have the civil code behind just so you can see exactly what the primary source is. And let's get right into it. So what are the lawful uses of a security deposit? Well, there's technically 5, but in this case, we're going to make it pretty high level. And that is, we have unpaid rent, damages, and cleaning. Now there's specifics that touch on those, but that's the general category. So the landlord is permitted to use a security deposit for at least all of the following. All right, these are the most obvious. There's some other areas that are more gray area, but let's start with what the rule is before we get into what the exceptions are. So 1, unpaid rent. And there's a caveat on that. Unpaid rent for future rent has to be specifically mentioned in the lease. So if a landlord wishes to use a security deposit to remedy a future default, then this provision must be expressly provided for in the rental agreement. So make sure that you are advising your residential landlord clients that they need to have this language in here. And what I often see with the clients that I help is that they go on the internet because they need a rental agreement or a lease. And the problem with the internet is that you will always find an answer, but you won't always find the correct answer. So you have tenants who either go out and seek self-help, or worse yet, landlords who are expected to know what the law actually says, and they download a generic lease from eforms.com. And oftentimes these websites are not privy to the myriad changes in statutory law or case law that pertains to residential landlord-tenant disputes. Many of them are not AB 1482 compliant. If you don't know what AB 1482 is, you probably don't practice real property in California. Feel free to raise your virtual hand and I'll address that at the end if there's time. But that was a landmark change in California residential real property. And that was right before things got even crazier during the COVID measures of 2020 and 2021. So there were all kinds of changes with the notices you had to give. So let me get back on topic here. And I know I have to keep the scope limited to just residential landlord tenant matters pertaining to specifically security deposits, not commercial, which is a whole nother presentation, just residential. So let's get back to the second point. After unpaid rent, then a security deposit can lawfully be used to cover the repair of damages caused by the tenant or the tenant's guests beyond reasonable wear and tear. So one of the most, I'd say, litigious areas, even though it's generally litigated in small claims court, for landlord-tenant disputes, one of the most common areas is security deposit refunds. And that is because, as I will get into, there are very specific processes that the landlord is expected to follow with very specific timeframes that many, perhaps even most, small, unsophisticated mom and pop landlords have never learned, because their excuse when I talk to them is always, oh, I've been doing this for longer than you've been practicing law, sweetie. I've never been sued. And they're probably right. They haven't been sued yet. So they're about to learn what the law is in front of a judge on the defendant's table in small claims court. And as a side note, I have enough experience in small claims court, not as a defendant myself, but as a judge pro tem, to know what these problems tend to be based on and how they can easily be mostly avoided. Not 100%, as you all know, nothing is 100%, but you want to add the odds in your favor. Don't make foreseeable mistakes and then get the foreseeable outcomes. So 3, cost of cleaning the premises to restore it to the condition it was in at the beginning of the tenancy. That's another gray area that trips up a lot of landlords, and I will discuss a way for you as a landlord or your landlord client to avoid these pitfalls in most cases. And the hint that I'm going to give you is it comes down to proper use of the move-in, move-out inspection report, as well as the initial inspection and the move-out inspection. So we talked about, just a recap, unpaid rent, repair of damages, cost of cleaning the premises, as well as 4 uncorrected damages that were identified during the initial inspection, but not corrected prior to the tenant's vacancy. So like I just spoke about, and I'll touch on it a little bit more a little bit later, is there is an initial inspection. Now, unfortunately, this initial inspection is news to a lot of landlords. They didn't know that they are supposed to notify their tenant of their right to request an initial inspection prior to their move out, so they can be apprised of what damages are going to be deducted from the security deposit and have a reasonable opportunity to cure before it's too late. So after that initial inspection, if the tenant hasn't already moved out their things, because they're still usually there for another 2 weeks, it's possible that damage might ensue during the move out period, or they had so much of their tenant's prized possessions covering the damage, perhaps intentionally, that those defects could not have been seen, therefore could not have been noticed to the tenant and therefore not cured by the tenant because they weren't notified of them. In that case, the landlord would be entitled to use a security deposit to deduct for those damages that arose in between the initial inspection and the move-out inspection. And that leads right into number 5, the 5th of the lawful uses of a security deposit, which would be uncorrected damages that did not exist or could not have been identified, during any point. So basically 4 and 5 are the same. But just keep in mind that you should, if you're the landlord, have the tenant mark freely everything that exists prior to their move-in, all the damages that existed prior to their move-in. And you or your agent, again, speaking as if you are the landlord, your agent should go with that new tenant so they're not marking off things just inappropriately, all right? They have to be reasonable, of course. And the analogy to why this is important is next time you rent a car, if you don't already do this, and it drives my wife crazy, but I'm not going to stop, you want to go around the car either with your phone, take a video, just walk around, and then point out all the pre-existing damage. Even if you purchased, that liability waiver that they always hard sell you with, that is usually more than the daily rate of the rental car, it just saves you so much headache of having to argue that damage was there before me. And then them saying, well, no, it wasn't. And it just goes back and forth. And what happens in small claims is if you have the plaintiff with no evidence, just using oral testimony to say A is true and the defendant rebuts with A is not true, and you have neither side with a preponderance of the evidence, the plaintiff is going to lose because they haven't met their 51% threshold. Okay, so I probably need to pick up the pace a bit since I do kind of have a hard break. Well, at 1, but I'm going to stick around a little bit to answer questions before I have to go over to, well, next door. So the landlord is entitled to use the tenant security deposit to cure a rental arrearage, such as unpaid rent, but the landlord is not obligated to. And the reason the landlord is not obligated to do so is that this could deprive the landlord of an important financial cushion to cover any damages left by the tenant. You used to see more often than you see now, first and last month's rent, and they would prepay last month's rent. And if they've already paid the last month's rent, what do you have left over to cover any damages? You've basically given away your security deposit. So is that a good idea? Survey says no. Okay, so unlawful uses of a security deposit. So the landlord or the owner cannot use the deposit for damages to the premises or any defective conditions that existed prior to the time the tenant moved in, which is why it's not just in the tenant's interest to go room to room and mark all the pre-existing damage. It's to the landlord's interest to have that, because everything that isn't in that first of 3 columns, in other words, everything that is not under the column of, pre-move-in inspection, whatever you want to call it, is fair game. That's presumed to have arisen during the tenant's tenancy if they did not mark it as pre-existing. But the owner cannot use the security deposit for ordinary wear and tear, whether that wear and tear pre-existed the tenancy or occurred during the tenancy. And that's one of those perhaps statutorily intentional gray areas. I don't know what more they could do to make it clear, honestly, but it's just something that is always going to be a highly problematic area, which is why you want to do everything you can in your favor or your tenant's favor or your landlord's favor, your client's favor, to put in place as many reasonable precautions to ensure that the unit was damaged during the tenancy, not before, and therefore it's fair game for the landlord to deduct to cover those damages. One useful measure is maybe take a video of the condition of the premises and timestamp it. One way you could do that is you're taking a video, or your agent is taking a video at the same time the new tenant is moving in and going room to room with that inspection sheet. You already have to have an agent there with them. So might as well use that to show this is very close in time. This isn't months before the tenant moved in. This is the same time they're doing the move-in inspection. So any damage that is not showing up in the video now is presumed to have arisen during this tenant's tenancy. Therefore, I have a lawful deduction from my security deposit, from the tenant's security deposit. All right. Don't make the mistake of grasping with, your cold hands all the monies in a security deposit. This is not your money. This is not your client's money if you are representing the landlord. This is the tenant's money that the landlord is holding until the landlord is going to make lawful deductions. But too many landlords just view a $2,300 security deposit as another $2,300 payout. And no wonder there's so many disputes. The tenant needs that money back in most cases, often more so than the landlord, although these days things are different. So don't even put that deposit in the same checking account, although you're allowed to, and you don't have to pay interest in most jurisdictions in California, not all. This is primarily for San Diego, of course, but it's better to just keep that in a separate account. Don't even commingle it because it's not your money. It's not your client landlord's money. It's just there for holding. So how to determine the maximum allowable security deposit. Now, just as a sneak peek, I did make a table at the end of this in case you're not following. I'll go back to that. And of course, this presentation will be made available for you, but it's important to break down how much you can charge based on whether the unit is furnished, which most people are aware of, but also whether your tenant is active military. So the max amount that a California landlord can collect for a fundable security deposit in California depends on whether the tenant is an active member of the U.S. military and whether the unit is furnished or unfurnished. So when I talk about active member of the military, this also includes and protects the immediate family members that are living with the active service member, immediate family members. So for military tenants, I'm going to talk about that next, but for now, I'm just talking about the average civilian, not active military, not member of the immediate family. So since most tenancies will be for non-military tenants, I'm going to discuss the maximum that's typically allowed. So if the unit is furnished, then it's 3 months. In other words, if your monthly rent that you're charging is $1,000 and the unit is fully furnished, you can charge a security deposit 3 times that amount, $3,000 versus, should be pretty obvious at this point, 2 months, $2,000. And I've tried to add the civil code to most of these slides. So don't take my word for it, look it up in the civil code. And if you need more elaboration, well, that's the place to go. So for military tenants, all they do in most cases for military tenants, keep in mind there's a caveat that I'll discuss in 30 seconds. They just lower it by basically 1 level. So if you have, and this is where it gets tricky. This is where I'm going to talk about something I didn't talk about in the previous presentations, because you can't ask their military status as a landlord. It's protected information essentially, because the legislature doesn't want military members being discriminated against. I'm a reservist. I've been in the Navy since 2007. I was always under the impression that employers and landlords would be happy to, hire people like me or rent to people like me. And being a reservist, it's great. It's benefited me tremendously, but I do have to train every month. And it's usually just 1 weekend, but once a year, it's at least 2 weeks. And I could understand firsthand why I would actually be less attractive as a candidate for employment or for a tenancy back when I used to rent, because I have protections under things like the SCRA. So it would be easier for many employers, easier for many landlords to say, I would just prefer not to rent to military. It's just easier not to. So that's why you're not allowed to ask. So if they tell you that they're active military, if they show up in uniform and salute you, well, maybe that's a good sign. Keep in mind that it's something that, we all have to make a sacrifice for, all right? We should be glad that people are volunteering, so we don't have to reinstate the draft. So encourage your clients to maybe put aside their biases and recognize that the upside to renting to military is that their pay, especially if they're active duty, is very consistent. So max amount of security deposit, real quick, if they're military, it's 2 months. If it's furnished, 1 month if it's not. However, if the service member has non-service member roommates who are not the immediate family members of the service member, such as, they're not the spouse, the parent, or the dependent, then the protection doesn't apply. And if the service member has roommates, again, the protection wouldn't apply unless those roommates are active military as well. So they don't get to have like the anchor tenant who's the military and then bring in all their friends and then now they're subject to all the military protections. No, it just protects the military and the military's immediate family. And then there's another caveat, and that is if that service member has a history of bad credit or damaging the premises or previous premises that you discovered during your background screening, then they're not eligible for this lowered threshold, and they therefore fall under the civilian category. And I'll show you that right now. So for those of you who prefer things obsessively orderly, which we're lawyers, so there's more than just a few of us here that do. This is a quick table. So 1 month's rent, that's the lowest. That only applies if it's unfurnished and the tenant is active military. And I admit that I am not confident whether this would apply to reservists such as myself. Nobody's asked me that yet, but I just thought of it. And if somebody is curious, then I will absolutely research it. I didn't see any mention of it in the civil code as for reservists, but that's a side issue that maybe I am the only one that is considering that. All right, 2 months rent if it's unfurnished and they're civilians, or if it is furnished and they're military. And finally, 3 months rent, the most you can charge if they are civilians and they're renting a furnished unit, or as I just discussed, if they are military with bad credit or rental history, then they basically fall into the category of average civilian. Not that there's anything wrong with being civilian. So, important distinction between security deposits and screening fees. So, one is always refundable, assuming there's no lawful reason to withhold. The other is never non-refundable. Let me talk about the critical distinction. So screening fees are normally never required to be refundable unless they weren't actually used for the screening purpose. And in some cases, if you don't have a unit available, well, you can't even charge a screening fee unless you agree with the applicant that there is no unit available. I don't have a unit foreseeably available in the near future. However, the applicant is agreeing to sign the application, pay the application fee with the hope that when a unit becomes available, the applicant, will be placed at the head of the list. So that would be decent enough consideration for a court generally to allow that. But normally, if you don't have anything available, or you are using this application fee as just another source of your side income, and you have no expectation of renting to this person, you're going to get in trouble if you're doing this. So what this is designed to do is compensate the landlord for a reasonable amount of the landlord's time, which needs to be documented, as well as to compensate the landlord for the fees that are associated with screening an applicant. So I will also talk about the new reusable tenant screen reports briefly, but I have a separate presentation on that. Before I talk about that in a sec, let me just say screening fees are normally never required to be refundable. It's under Civil Code section 1950. Look at 1950.1, 1950.5. And these are fees that are paid at the beginning of a tenancy to be used to reimburse the landlord for costs associated with screening a new tenant. But if your tenant would like to use a reusable tenant screening report, well, they can, and they should be encouraged to do so, because the amount will add up very quickly if the tenant is applying to multiple tenancies, which these days you have to because it's a tight rental market. And what Governor Newsom signed into law, which took effect this year, January 1st, is AB 2559. And that can save the applicant from paying up to $55 an application as long as the requirements are met, meaning it satisfies certain statutory criteria, that screening, the reusable report, the reusable tenant screening report has to show specific types of background checks. In other words, the information that a landlord typically would want to see, and it's usually valid for 30 days. So the tenant, the applicant who's applying to become a tenant might apply to over 5 different tenancies. And instead of having to spend over $200, $55 each time, they can spend it perhaps once. And if the landlord accepts the reusable screening report, then the landlord shall not charge the tenant a fee, and the landlord shall not be charged a fee from the tenant. So it goes both ways. Now, the landlord is not obligated to accept reusable tenant screen reports. The landlord, if he or she chooses, can still do it the conventional way, but it is a convenient option that I urge you to try to, sell to your clients, not against their will, but many of them aren't even aware it exists. So at least enlighten them on this new option, because it really is a lot more fair to the tenant. So the move-in inspection. Now I'm going to include some samples of the forms. Do not use these samples. It says preview on it. That should be a sign. I do provide these forms. I have many landlord clients. I will help tenants as well, but I do offer kind of a one-stop shop, an all-in-one package where landlord wants to hire me and I can completely streamline their business, which it's a business, all right? Everything from accounting to, most importantly, the backbone of their business, which is the agreement. All the agreements are basically the most important thing. They have to be done properly, timely, and they have to be done on the current forms that have the current statutory language. So I use a program called Door Loop, which is one of the categories like Yardi or Buildium. And if you aren't familiar with this and you advise your clients, on how to manage their own single family or multifamily properties, I really encourage you to look into this whole category of software. It's got a really unfortunate acronym. It's PMS, but it's Property Management System. And I prefer Door Loop because you can manage it from anywhere. It's all in the cloud. And just as one example, when you have an applicant, you don't have to meet with them. You don't have to do the whole paperwork stack where they fill out other information. You don't have to incur the liability of running the background check yourself. All you do is get their name, phone number, and email, and then you send them the URL to your property. They will apply. It allows them to pay the screening fee, which you can set. So you can set it up to statutory maximum, and you pay nothing. And they will even compensate you the difference to make up for your time, as long as you document that. And the applicant does all this. They do basically one through 6 steps that you normally had to do manually by filling out the application. And then it triggers the automatic background check through TransUnion Smart Move. And then once that's completed, it comes back to you and you can see what their overall tenant score is. It creates a score like a FICO score. And you, meaning you, the landlord, can decide whether to give it a thumbs up or thumbs down and give them the next step, which would be the lease agreement, which is done electronically as well. They use Dropbox Sign, which is like DocuSign. So instead of having to send them or meet with them and have them fill out, all these different areas, which they're going to overlook, you give them this electronic agreement and they will just sign it like DocuSign, and they can't skip any required fields. And in most cases, like most click-through agreements, they're just signing whatever you have, which, I'm not advising you to encourage, but that's the reality. So that's not a pitch for my services. If you do want to talk to me about this, I'd be happy to. I'm always looking to meet with other lawyers. So let's get right back to the move-in inspection. This documents all the damage prior to the move-in. And this is so important because by documenting all the pre-existing damage here, this is so important for the tenant to not be held liable for anything that predated them. Think back to the rental car analogy, right? All that damage that pre-existed your rental, you might be held liable for if you don't document that that damage was there prior to your rental. And if the tenant doesn't want to take the time to do it, they just say, yeah, everything's fine, I got to get back to Netflix. Then that's good for you, because now it's assumed that all the new damage, which is going to arise during their tenancy, which you, the landlord or your agent, will discover 2 weeks prior to that move out during the initial inspection, all the things that come in this column now are presumed to have been the fault of the tenant. And then when it does become litigated in small claims and the tenant says, no, those walls were damaged before I moved in, that countertop was cracked. Well, that may be true, but if it was true, why didn't you mark it? Well, that's fortunately what happens. So just have your landlord, have your client landlord go with them. If the applicant, now tenant, is filling out this column, then you just go with them and you document it. And you could even say to the tenant, and this is reasonable, that look, I'm just making this video to protect both of us. So if there's any dispute, then we can show that there was damage here. Allow the tenant to point out the different areas of damage, so it's fair to the tenant. That tenant could use that video as well, and therefore it's presumed that anything that isn't in the move in, move out statement, especially not in the video, is absolutely fair game. I think you will have definitely committed a belt and suspenders secure approach in that case. If you do that move in, move out report, that's usually all you need. If you want to take a step further with the video, that's voluntary, but I don't see the harm in doing that. So you also want to write an email to, sorry, phone, my fault. So if the landlord does not allow the tenant to go room to room, that should be a red flag. For those of you who are advising tenants, make sure that they have the opportunity to do this move-in inspection. And if they're impeded, if there's not a form that gives them room to mark all the damages, that's a red flag. And they should tell their landlord that they are going to have to consult with you, their lawyer, before they accept this tenancy. All right, so that concludes part one. That was prior to the tenancy beginning. Now we're going to talk about prior to the tenancy ending. I have about 27 minutes before Q&A starts, so I'm going to go quickly through this. Wish people would stop calling me. And we have next the move out inspection, also known as the initial inspection. So here's where a lot of landlords figure out what the law is from a judge as a defendant. They don't understand that after either the landlord or the tenant notifies the other of a normal intent to terminate the tenancy, I'm not talking about 3-day notices and commencement of unlawful detainers here. This is typically when the tenant gives a 30-day notice, landlord gives a 30 or 60-day notice, just normal course of events. But it's after the tenant or landlord gives the notice, but before the tenant vacates the premises, a California landlord is normally obligated to provide the California tenant of the tenant's right, but not obligation, to accompany the landlord for a pre-move out inspection. So the reason they call this the initial inspection is that it predates the final inspection, which comes after the tenant's departure. So that's why, all the forms that I use, is you'll see on the next screen, they're always 3-column forms. You have that pre-move-in inspection, you have the initial inspection, you have the final inspection. There's different ways to title those columns, but that should give you a clear gist of it. Now, the optional pre-move out inspection, aka the initial inspection, affords the tenant the opportunity to address curable defects in the property that arose due to that tenant's tenancy. And if the defects are not either cured or curable by the tenant, then it should be presumed that the landlord will deduct from the remaining security deposit the cost of curing these defects. In other words, you don't have to allow the tenant to cure every defect if they're not qualified to cure it. If they damage the plumbing and they're not a licensed plumber, don't allow them to watch a YouTube video and order the parts on Amazon. They can pay out of pocket with your permission. So make sure that your tenants are always communicating with you every step of the way. It's like a relationship. Over communication is generally preferred, at least by one side. So during the move out inspection, then it's going to be too late for the tenant to defend or cure anything. That's why it's important to do this during the pre-move out inspection. And this is where the tenant should also accompany the landlord or landlord's agent, because the landlord or landlord's agent now is the one marking the form. Remember, in the first inspection prior to the move-in, it was the tenant that was marking the damage form. And now it's the other person. And if you want to switch the camera roll so the tenant is now recording everything, that's fine too. You can't necessarily restrict the tenant from recording in the premises that they're still in lawful possession of. So do you know why this inspection is especially important for the tenant? It's because the tenant needs to have that opportunity to cure. Even if they're not allowed to, they still have to be presented with the opportunity to have that pre-move out inspection, and B, the opportunity to cure what is allowed to be cured by the tenant. And the tenant should respond in the affirmative to the landlord's offer to do this initial inspection. This is one of those things where people foreseeably make mistakes. They make foreseeable mistakes. They get foreseeable outcomes. And it could be avoided if they were to just take a TikTok break from scrolling and spend the time to do this properly and request the initial inspection. What I often see is that there was never any dispute between the two parties. It was a perfect tenancy. They lived in harmony. Maybe it was even, one of those where it was like a duplex and the landlord lived on site and they would have pasta dinners every Friday. They never had a problem. So the tenant didn't think I needed to spend my valuable time on my initial inspection because it's never been a problem before. Well, like most things in life, nothing is ever a problem until the first time it is. So err on the side of prudence and advise your tenant to accept the landlord's offer of the initial inspection, and advise your landlord to offer it, not just because it's, a courtesy, it's a requirement. So the form that you should use has 3 columns. It should have enough space to write in details for everything. And keep in mind, what's that expression go? It's fair for the goose, it's fair for the gander, whatever that actually means. If you're not giving the tenant enough room to write all the pre-existing damage on the move-in inspection, then you're probably not going to give yourself enough room to write all the damage that they caused on the initial inspection or the final inspection. So it protects both sides. And as you can see here, it's a very detailed report. If you look closely, you'll see that, all right, here's the first page, and it talks about kitchen, and not just kitchen, but ceiling, doors, walls, floors, hood, fan, all right? It's broken down to the granular level within each room. That's why in the second page, it talks about things like the stove and the oven, all right? What I often see is that this is all encompassed within just one category. Kitchen, yes. Kitchen, no. I have a client right now who's just saying, like, it's too long. Just make it one form. Make it simple. Make it simple, Nick. And he always wants things simple until things get complicated because of his emphasis on simplicity. If you say, kitchen, no good. Then what part? What are you talking about? You have to break it up into the specific areas. Don't be so lazy. All right, now, and then for systems, it talks about smoke detectors, carbon monoxide detectors, furnace, thermostat. So during the move-in inspection, that is important because you need to show that all of your smoke detectors and carbon monoxide detectors not only had batteries, but they weren't chirping, they were actually functional, and they weren't painted over, they existed. So if a tenant is paying attention, they should see like, oh, there's no smoke detectors at all. Big fat zero. All right, so next, coordinate the post move out correspondence prior to the move out. Another area that landlords get tripped up in. How do you reach your tenant after they vacated? They often change their number. They don't have an address that they've given you for a forwarding address. So it's foreseeable they're going to be out of your premises and you need to reach them. Why? Well, you have 21 days to give them the itemization, the disposition of what you deducted from the security deposit. You better know where to send it. So the landlord and the tenant should mutually agree to have the landlord provide the itemized statement and receipt substantiating the costs incurred in restoring the premises to its pre-tenancy condition via email if you can. All right, email is probably not going to change. It might, but it's less likely to change than their address. And after the tenant vacates the premises, reaching that former tenant can be a lot easier if you can just send them an email that is unchanged. Because if you try to just ask for their forwarding address, well, that's okay, except they're probably going to have several different addresses in the meantime. I was in court yesterday helping a client. This was at mediation conference, and it was a security deposit dispute, and the outgoing tenant who had moved out lived at their friend's house, and then they lived in a hotel, and there were a few other places that the landlord had no idea how to reach. And that is a burden for the landlord. It's a problem for the landlord because you're under a statutory obligation to act within 21 days, even though your client is going to have a really good excuse for why they tried to reach the client and the tenant, and the tenant just didn't answer their phone. All right, it's foreseeable. There's so many things in life that are not foreseeable. You have to deal with those, but there's no excuse to not take advantage of the things that are foreseeable and within your control to control. So to make things easier for both sides, the landlord and tenant should agree while they're still on speaking terms to have the landlord provide the itemized statement and receipts substantiating all the costs incurred in restoring the premises to its pre-tenancy condition via email. And you should have a security deposit disposition agreement, such as the one that you see here. I put stample on there so you can't steal it and use it for your client. And this gives the boilerplate information, but it says the parties agree as follows. Landlord, check as applicable, electronic direct deposit, security deposit. So the parties can agree that the landlord, instead of sending the check using 20th century technology, paper check in the mail that's probably going to fall in a giant IKEA catalog and get thrown away, might as well use a more intelligent approach, which also helps you prove that you sent the check, because now you have basically two-party authentication. You, as a sender, have a way to authenticate that you deducted this from your checking account and sent it, and the tenant should have the ability to go through their statement and see, oh, it was automatically deposited. That was nice. Now, certified mail is a really popular option for people that don't really think you could just send an empty envelope and get that certified, and there's no way the post office can prove what was sent. I don't believe in certified mail. It also, in most cases, allows the tenant to not accept it if they want to screw the landlord and say, look, I never got it. You never delivered it within 21 days. So I don't like certified mail. It just proves that you sent an envelope, at least. That's it, right? So the disposition agreement would allow the tenant to fill in their bank information, their account number and routing number. And before they freak out and say like, well, I don't want to give my landlord my account number and routing number. Well, have you ever written a check? Look at the bottom of the check. It's probably right there. So when you give it to the cashier at Walgreens, you can probably give it to your landlord. And then it also has a slot for their email with a check for the tenant to say, yeah, you can email me my documentation. You don't have to, send it through a singing telegram or mail. And then I just urge you to maintain good relations with your tenants. Again, speaking through you, the landlord, speaking through you, the attorney, directly to your landlord client. It's always easier, to keep that bridge up because you never know when you need to cross it rather than destroy it in a fit of rage to try to get some fleeting pleasure that you punish the other side. It's usually just going to punish you more when you can't communicate with your tenant. I had a client, he's okay, let me tell the story. He had a tenant who put up a giant sign in his window naming the landlord, and I wouldn't use that tenant as a testimonial. Let's just say that it was not flattering. So they couldn't communicate. And then it just spiraled out of control. And he tried to use his friend. He didn't have a property manager. But things are always easier if you can maintain channels of communication. Look, like this is an area that gets very heated for understandable reasons. You're talking about someone's house and you're talking about the other person's livelihood. So what do you expect? There's going to be conflicts. But if you can take a pause, not answer the phone when you or the other person or both are heated and are about to argue, take a pause, write the email, and then hold it overnight, wake up in the morning. And if you still need to have that many all caps, well, maybe go for a jog and then send it if you absolutely have to. But chances are, before you send it with your typographical screaming, you might need to just tone it down a bit. So be careful about just communicating in the heat of the moment. Next, the waiver of documentation. Now, this is a request that most landlords don't consider prior to the recovery of possession of their unit, but should consider. And this is a request for the tenant to waive the tenant's right to receive some of the documentation that normally accompanies the notice of any security deposit deductions. Because normally a landlord is obligated to provide a form with a line item breakdown of each expense that is being deducted from the security deposit, along with receipts to the tenant within 21 days of the tenant's departure. These are calendar days. These aren't court days. So if the landlord can negotiate the tenant's voluntary waiver of the tenant's right to such documentation, it can relieve the landlord of a paperwork hassle that the tenant might never even read. So it's just kind of a useful exercise in pointlessness where the landlord is expected, and if they're a prudent landlord, they shall acquire all of the associated receipts, and not just generic receipts, but ones that have the letterhead. And make sure your clients understand the difference between an invoice and a receipt, because many don't. And this waiver can be made at the time either party tenders notice of termination or notice of non-renewal, but no earlier than 60 days prior to the expiration or termination of the lease. Okay, so in other words, don't include is waiver of right to receive documentation in the new lease as just part of your standard forms. All right, it can't be asked of the tenant until the conclusion of the lease. And also both sides should always save copies of any correspondence one side says to the other. And this is especially important for the landlord here. So not only does the landlord need to save a copy of any executed waivers, such as this one, but the landlord should also scan and save copies of all receipts and documentation, even if the tenant agrees to a waiver, in case the waiver is later challenged or in case the former tenant changes their mind after seeing how much of the subsequent itemized disposition of security deposit amount was withdrawn, which amounts to less than what they were expecting. And in that case, if the tenant demands proof of expense after receiving the itemized disposition and seeing how much of their security deposit was withheld, then the tenant may request and the landlord shall provide all receipts and documentation substantiating the landlord's withholding of the tenant's security deposit. So make sure that you are keeping track of communication. And one way to do that beyond just these letters and correspondence is through email, which is great, and even better yet, text message. So many of us now communicate with our tenants through text message. And that program I mentioned, DoorLoop, you can send text messages to any or all of your tenants, to any or all of your properties, and they can have, it's usually one-way text that way, but they can communicate with you through the portal. And when they do that, the less obvious advantage than the obvious advantages, the less obvious advantage is that it's timestamped. They can see that you acted prudently. They can see that you responded to the tenant repair request. They can see that the notice was delivered, within 24 hours. Now, that's a new area of law, whether the physical posting of the 24-hour notice prior to entry can be posted or can be delivered electronically with the tenant's advance consent. But another thing is talking about text message communication. If you are going to use the text communication in court as an exhibit, I urge you to advise your client to archive all the texts. Don't delete anything. Archive all the text using a program such as like SMS backup. Go on the App Store, go on the iOS store, and while they're thinking of it, archive all the communications that existed between your client, your landlord client, and the tenant. And what it does, instead of what people often do, is just take screenshots of their iMessage, pages and pages of screenshots. This puts it into either an Excel format or CSV. It makes it abundantly clear which side was talking and at what time. It adds a timestamp to every conversation. And that's incredibly helpful when you need to show what was agreed, expressly agreed. That's why text message in most cases is better than just phone calls or in-person communication, because how do you refute someone's oral testimony that you said this when it's just their word against your word? Now, part 3, this is going to be the fastest one because it has to be. I have to go. Security deposits in California after the tenancy ends. So after the second inspection, again, known as the what? Initial inspection. This is assuming that the tenant had requested that optional inspection after it was provided to the tenant through that offer, so the form, which the landlord always has to offer, the tenant doesn't always have to accept. Then the third and final inspection will be conducted by the landlord without the tenant's presence after the tenant has fully vacated the unit. Now, this might be known as the final inspection or post move-out inspection. And during this inspection, the landlord or the landlord's agent will go through the same rooms as during the previous initial inspection and the pre-move-in inspection and verify that the damages that were discovered during the initial inspection, remember, inspection number 2, have been rectified during this inspection, which is inspection number 3. And if they have not, or if the damages that could not have been seen, new damages that arose since that initial inspection, or just, were intentionally concealed, are now found, then these damages will be documented on that post move out inspection form. The landlord must make and provide a copy of this post move out inspection form, as well as all of the associated receipts for the expenses borne in restoring the premises to the same condition it was in at the beginning of the tenancy that just concluded. So just take you back to that 3-column form. This is how it looks. And I don't know if you can see it. I think there's a law library Zoom window that might be blocking the final inspection. It says final inspection. If you can't see it there, let me just go back for you real quick. You see that now? Final inspection, right? We're talking about the final inspection now. And that is where the tenant is in the mercy of the landlord. Tenant hopefully didn't cause any damage, and if they did, or their guests did, or their kids did, or their pet did, hopefully they rectified it before this stage, because now it's too late. So the itemized disposition of security deposit has a few important dates to remember. So within, but no longer than 21 calendar days after the tenant vacates the premises, the landlord must provide the former tenant with a statement that confirms the amount of security deposit originally received, as well as the amount being withheld, the reasons for the withholding, and any receipts to substantiate the basis for the withholding. So if the landlord or landlord's agent did the work Then they must ensure that the work was performed properly and properly detailed with the hourly rate clearly posted, as well as the number of hours spent on each task. And if the work was done by a contractor, which in most cases it is, and it's less problematic when it is, then the receipt needs to be from that contractor's company with ideally a letterhead identifying the company and the company contact info. All right. I've seen literally receipts from purported contractors that were on a legal pad. I wonder where they got that legal pad from. So it was just given to them. It was so sloppy. They just wrote in handwriting, I worked for 4 hours at $50 and this is what I charged the landlord. Like, just because you can admit that in evidence during your trial doesn't mean you should, like most things in life. Just because you can do it doesn't mean you should. So the landlord must never charge the tenant more than the landlord actually paid the contractor or the vendor. Now, this itemized disposition, it should always be given, but it doesn't always have to be. And here's one reason why it might not need to be. If the total amount withheld does not exceed $125, or if the resident agreed in writing to waive the right to an itemized disposition, then the landlord is not obligated to provide an itemized disposition. And we talked about that waiver earlier. But as a reminder, such a waiver is only valid if given to the tenant after either party provides a notice of termination and no earlier than 60 days prior to the date of termination agreed upon. And lastly, before the landlord prepares and delivers this itemized disposition of security deposit form, it is advised that the landlord and tenant agree on a security deposit disposition agreement, which I talked about, right? And if the landlord is not able to have the work completed within a 21-day statutory deadline, then the landlord must provide a good faith estimate of the charges yet to be made. Then within 14 days of the completion of the work, the landlord must provide a final itemized disposition after either a credit of the overage or an invoice for an outstanding amount. And if the tenant initially waived that itemized disposition, but later changes their mind and later requests it, then the landlord must provide everything within 14 days. That's why I said you always need to save everything if the landlord even thinks that it might be an issue. And if the tenant waives, they're right, you still have to save everything. All right, so I'm gonna have to skip over these I think I'm gonna skip over forwarding address issues. This is why I always have a notice of renewal, or if the tenant says, no, I'm not going to renew, then they provide their forwarding address in one fell swoop. They decide, yeah, you can send my deposit to direct deposit. It's all just built in. That was on this previous form that I was talking about. And then what to do if ownership transfers, then you have to let the tenant know who is in possession of your security deposit, of the tenant's security deposit. You must inform them in writing. A lot of landlords don't know that. What if the damage exceeds the deposit? Well, you can decide to sue the tenant, or you can work out a post-tenancy payment plan and make sure to inform the tenant of the itemized disposition of the security agreement that there's a balance due beyond the amount that was withheld. That's another reason why you never want to just use that security deposit for the last month's rent in advance. All right, now this is what I normally don't do to my audience, but you guys are lawyers. I don't understand this clause. And if somebody does, I'd like to get your help. I don't understand what it means under Civil Code Section 1950.5, subsection C, subsection 3, additional deposits for minimum 6-month leases. Moreover, in long-term leases of 6 months or more, advance payments of not less than 6 months rent are permissible. Why do they have to make everything like the double negative? So if you reverse the double negative, make it a positive, is this saying that in a long-term lease of 6 months or more, then an advance payment of at least 6 months is permissible? So you couldn't request less than 6 months rent? I have wasted much too much time on that. And if you have an easy, clear answer to help me understand that, please share. All right, special situations. I know that like less than a minute left. You can you can allow your tenant to make disability modifications. You shall allow them, but you can't charge them an additional security deposit. What you can do is get them to expressly agree to reverse all the disability modifications at the end of the tenancy and agree to deposit a payment based on a reasonable estimate of the restoration cost into an escrow account to ensure restoration at the conclusion of the disabled tenant's tenancy. And look, that's a different civil code. It's on the screen. It's not like the other civil code sections we've been talking about. Also service dogs, right? Also a different civil code section from what we've been talking about. Obviously, you can't say no to a legitimate service dog. You got to be careful, even if it's not legitimate. You cannot charge a disabled tenant an additional security deposit, but you obviously can charge the tenant for damage done by that real or not real security, service dog. And family daycare, again, cannot charge more than the statutory maximum, but you can charge a higher security deposit than you otherwise would have charged. You just can never go past that statutory maximum. Okay, we did it at 1 p.m. So please help me improve. What did you find helpful? What can I improve? I hope you didn't fall asleep. And if you did, I hope you're awake now. Thank you for your time, and you're welcome for the MCLE credit.
Thank you, Nick. So it looks like we just received one question inquiring about how to obtain copies of the slides. So I can take care of that. The certificate and the slides, it's going to be the handout for the CLE class will be sent out to you guys later this afternoon. So be on the lookout for that. And then I just wanted to remind everyone again about the survey link that will be at the end of this class. We really appreciate those who take the time to provide us with feedback, and I'm sure Nick would appreciate it as well. So if you guys wouldn't mind, taking some time and doing that, we'd really appreciate it. So thank you, Nick, for the lovely presentation, and thank you all for joining us. Have a good day.